It looks like we're ready to begin. Welcome to everybody. Even though we still have some people showing up, we will welcome them as they arrive. And this is the next in the series of webinars that we have conducted on behalf of the Subcontract Management Institute. SCMI has developed the global standard for subcontract management under publicly funded contracts. So let's move on with the entire presentation. And we're here. Which law applies? Today's purpose is to help you understand that there are different bodies of law and they apply in different situations. And this is the webinar series for SCMI for July. Here's the content of what we'll cover today. We're going to talk about the body of law type of question and why this becomes so important, and it is too often overlooked. And then we'll talk about the different bodies of law that might apply to any given agreement that you're entered into, whether it's the federal common law, the UCC, or the UN Convention for the International Sale of Goods, one that is very viable and very widely used, except many people in contracting have not run across it. So we want to make sure you're aware of it because it can trap you if you're not careful. And we'll talk about some future webinars, but we also have a very special announcement coming up about SCMI and its certification program. So who is SCMI? It was formed to establish and maintain the global standard for subcontract management and administration. This had never existed previously, and when a client came to us and said, set up the global standard and train us to it, we went out and looked, and there simply wasn't one. So we created it. We've established a certification program around that gives people the skills, knowledge, things they need to perform effectively on that. And we added something that's a little different in some of the certification programs, because after you complete the training that we offer, the only thing you get is a certificate of completion of the training. And we send you back into your workspace for 6 months. At the end of 6 months, we come in and assess, did you really get it? Are you actually doing it? Because if you're not doing it, then you really haven't learned it. So we have an experiential piece to the certification. And you have to pass that before you actually become certified as a subcontract management professional. Here's the value proposition for SCMI, where we establish the global standard for subcontract management. And what's the goal here? It's a very simple goal. The goal is to reduce performance risk. It's really that simple. If you can avoid the risk, then you can have better performance, you can have better relationships, you can have all kinds of good things come out of managing the risk effectively and not bearing too heavily on one of the parties versus the other parties. So we ask the question, which law applies? Well, the starting point is an article that we put in Contract Management magazine a while back, and it identified 5 key differences between managing a subcontract and a government prime contract. And the very first one that it addresses is governing law, which is what we'll talk about today. But there are others that make big differences in the way you would manage contracts. The flow-down clauses, the scope definition, and how you measure performance. The inapplicability of many prime requirements, which is not always recognized by the primes, who seem to staple a whole bunch of forms together and say, here are the subcontract terms and conditions. Very bad management practice, but it's done, and many subs have seen this. And the last one that we point out in the article is the fact that subcontract administrators are not contracting officers, and they do not hold the authority of contracting officers. They have similar authority, but it's in a different context. And we jump back to number 1 then and say, well, why is that? And it's because different body of law governs these things. There's an article that we've referenced here for you. This particular version is on my website for my company, CertifiedCaseSolutions.com. I think we got it posted to the SCMI website, and because it was published in Contract Management magazine, it's available to NCMA members through the Contract Management website as well. But these are the 5 differences between managing a subcontract under a prime contract and managing a government prime contract. There are definite differences. So today we're going to explore this governing law issue. And the starting point, whenever you're working with the federal government, is the Constitution. The Constitution is the charter, the founding document that creates the government within which we function. The federal government exists because the Constitution says it exists. But for that, we would not have a government. Now, there's a clause in the Constitution, and it's called the Supremacy Clause. And it's an interesting clause because it establishes the fact that the federal government, as created by this Constitution, is the paramount authority. And it does this by saying that the laws of the U.S., excuse me, the laws of the U.S., which the Constitution says are the authority for those are vested with the legislature, the House and the Senate. But the laws that are made under this Constitution, and then it says, and all treaties made or which shall be made under this authority of the United States become, and these are the key words, the supreme law of the land. It is the highest level of law. If there's a conflict between that and any other law, the supreme law controls. And then it goes on to say, and the judges of every state shall be bound thereby, anything in their state constitution or other laws notwithstanding, meaning they don't matter. This is the supreme law. This one controls. Now I'm going to come back to this towards the end of our presentation, but I just want to make sure that you get the fact that this also includes not just the laws, but the treaties that are made under the Constitution. So if we're going to talk about the body of law and what controls, you have to ask the question of what is the law? And it's not just the man, it is the law. So I've given you a chart here. I'm not going to read this to you at all. There's a lot of data on here, and we're not going to cover it in any detail, but I want to give you the flavor of what jurisprudence is all about. Jurisprudence is the theory or the philosophy of law. You ask the question of why are there laws? You say, well, it's to have an organized society. Okay. But you can organize a society a lot of different ways. And you can do that based on a number of different theories in terms of how the law will be put into place, how it will be managed, how it will be disciplined, how it will be enforced. A lot of different ways to look at it. Now, jurisprudential theories actually cover a broad range of ideas and theories. It's a bit of a moving target in the sense that the more we think about the philosophy of law, the more ideas come forward. And so gradations of all of these occur. It's a continuous spectrum more so than a defined pocket that each one of these fits into. And this is just four of probably, depending on how you define it, 7 to 12 different prominent theories of jurisprudence. But natural law is the one under which our governing documents were created. Now, Thomas Aquinas, who was a natural law follower and wrote extensively about it, he said that the first precept of the law is that you do good and you avoid evil. That sounds pretty basic, but it doesn't always work out quite that way. All other precepts of the natural law, he says, are based on the fact that you want to do good. So if you think about the natural law, and some people say, well, I don't follow the natural law, I follow some other theory, and that's fine. There can be a place for other theories. But let me give you this example. If you step off a 20-story building, you can believe in the law of gravity or not believe in the law of gravity. Because, you see, the law of gravity doesn't care what you believe. Gravity will take effect and pull you down. That's natural law. And so the effect of it, as you saw in the prior chart, is that man does not make natural law. He discovers it and then uses it as the baseline for the moral authority of the laws that are put into place. And that is the fundamental theory behind the laws of America. Not true in other countries. As I said, Constitution and Declaration of Independence are natural law documents, and the pursuit of life, liberty, and happiness, well, life, liberty, and the pursuit of happiness. Those are the good things that we seek. The government then, U.S. government, is one of delegated powers. Since the Constitution is the charter, unless the Constitution says you can do certain things, you can't. And the 10th Amendment, the Bill of Rights, 10th Amendment of the Constitution, says that unless the power is given to the federal government right here in this document, then it is reserved to the people or the states. And once again, we see that in establishing the federal government, it was acknowledged that there would be these other entities, these other governing bodies, the states, who would have their own rules and their own way of doing things. But what's interesting about this is, as I say, the Constitution, unless it says the government can, it can't. For the states, unless something says it can't, it can. It's the opposite approach. And so from this set of principles, we have what's called the federal common law that evolves around how the government is established and how it effectively administers itself and the justice under the laws of the United States. So Congress has the power to make laws. The Constitution says that. And here are the two major laws that we run into when we talk about federal acquisition. Armed Services Procurement Act and the Federal Property Administrative Services Act. Between the two of them, they cover pretty much everybody. There's a couple of entities out there that don't have to follow this. For example, the FAA is allowed to have their own set of principles on acquisition. Airline safety is such an important area and needs the flexibility that Congress said, FAA, you don't follow these laws. You can do your own regulations in this area. And they, in fact, do. Congress, of course, has never seen a single problem that it can't find a law to cover, and so they make laws all the time. This is a teeny tiny sampling of the kinds of laws that you will run into with the federal government. The Tucker Act goes way back, as you can see, and this is the one that waived sovereign immunity. It allows people to sue the government when it is engaged in commerce, as it is in its contracting capacity. And pay particular attention to the 5th and 6th bullets on this chart where we mention the annual Authorization and Appropriations Acts, because these days this is where Congress most commonly tucks little goodies. And I say that in a bit of a sarcastic tone because these little goodies are sometimes good and sometimes not so good. But they're hiding. They're in the money side of things. Because they hold the purse strings, they get to say how money is going to be spent. And again, this is often done on the basis of a particular theory of jurisprudence. From that body of law, then, we have a set of regulations that have grown up, and this is all spelled out in FAR 1-201. You have these FAR councils, and they consider input, and they, in fact, put together the regulations. It's updated regularly, about 7 to 12 times a year you'll see an update come out. And then, of course, each agency has its own FAR supplement that says, okay, FAR, we got it. Congress, we heard you. We got the FAR. Now, here's how we in the agency are going to administer it. And if you're doing business, for example, with the Corps of Engineers, think about the level of regulations that you have to follow, because, again, you still have the laws, you still have the FAR, but then you have the DoD FAR supplement. And beneath that, you have the Army Acquisition Supplement. Below that, you have the Corps of Engineers supplement, and within the Corps of Engineers, they're organized into districts, and you have the district rules that have to be followed. You've got like 5 levels of regulations to follow just to do business with this one entity. So this whole regulatory scheme becomes very, very important, and it's rooted in that body of law behind the government prime contract. Now, we're going to look at this chart twice today. This is the first time. And what I want you to get out of this chart is that we have a lot of courts making a lot of decisions. And for prime contracts, I want you to focus on the left side of this chart, where you have the federal district courts, special courts, and BCAs, and the Circuit Court of Appeals. Don't worry too much about the magistrates, but those are the guys at the lower level. You get yourself a speeding ticket on the Baltimore-Washington Parkway or in a national park, you're going to end up before a federal magistrate. Federal district courts are where suits are typically started. But over here in the special federal courts, there's one called the U.S. Court of Federal Claims. And this is a very important court for purposes of government acquisition, because protests and claims can be taken to this court. Now, over to the right of that, you see these BCAs. That stands for the Board of Contract Appeals. There are now 2 of them, DOD and civilian. And you'll notice we've got a dotted line here to connect them. Why is that? Well, you see, the BCAs are not courts. They are administrative bodies acting in a judicial way. And decisions from the BCAs can then enter the court system and be appealed. And so we put the dotted line there to reflect that this is not a court per se. It is an administrative body. So trials start here or possibly in the special federal side. They can go to the Court of Appeals for the proper circuit. I won't get into that detail today. And can ultimately be taken to the Supreme Court if the Supreme Court says, yes, you can. You see, to get a case before the Supreme Court, you have to play Mother May I with them. Heck of a job these guys have, because they get to decide their own scope of work. They get to decide which cases they will hear. And it's done by a process called a writ of certiorari. And the Supreme Court will respond to that way. So we're going to leave the right-hand side of this alone for a moment, but I will emphasize this dotted line you see here connecting the state Supreme Courts up to the U.S. Supreme Court, because, again, there is no right to get there. Certain things must be considered before you can get out of the state court and into the federal side of this. But prime contracts, left-hand side of this chart, and they've got their own courts, their own law, their own regulations, their own everything that creates the body of law known as the federal common law. So from this point, we now start looking at the prime contractors and their subcontractors. Because whenever you're entering into commerce, these are some of the questions that you have to consider. How do you know when you have a contract? And in fact, what do the courts look to in order to determine whether a contract even exists, let alone what it requires? And if you ask the question, then do all courts use the same criteria? Well, you would think if they're operating under the same body of law, they probably should, but that's not always the case. And more importantly, in fact, this is a very recent issue, what do you have if you don't have a contract? There have been several cases that have gone through the Northern District of, or excuse me, the Eastern District of Virginia, that have decided that certain teaming agreements that people thought they knew what they meant and what they required of the parties don't quite mean that, because they are not even really contracts. So this whole area is still very dynamic, and people who don't pay attention to what body of law controls and what the effect of applying that body of law has can get themselves in all kind of trouble. I'm going to refer you to another article that we've published out there. Again, it's on my site. I think it's on the SCMI site, but it's definitely on the NCMA site as well, where we ask two key questions. This is a two-part article. And ask two key questions, and I always used to have fun doing this, going up to contracting officers and saying, so tell me, you've got this contract with such and so party. What is the contract? And you get this deer in the headlight look of, well, what do you mean? The contract is the contract. It's like, well, can't always be so sure of that. There's a lot of parts to these contracts, and if they're not incorporated properly, they ain't part of the contract, and it can cause people some problems there. So that's the first question. What is the contract? And the second question, which we'll reference in a later chart, second part of the article, and it says, and how do you know when it's done? The inspection and acceptance isn't always as clear as you would hope it would be for these kinds of things. But once again, depending on the body of law you are under, the answer to what is the contract and how do you know when it's done could have very different outcomes. So if you've all taken Business Law 101, you all know that there are 5 essential elements to a contract. You've got the offer, you've got acceptance, you've got consideration, competent parties, or in the case of the government, authorized parties, and a lawful purpose. And under the general common law of contracts, which is followed by the feds, you got to have these things. If you don't have these things, you don't have a contract. The rules of federal expenditures are very rigid, and so you've got to follow all of these rules. In the FAR, you have several different principles that are always paramount. Competition, FAR Part 6, full and open competition, you got to have an exception if you're going to limit it. Fair and reasonable pricing, because it's the public money. Low bid or best value, depending on whether you're doing a FAR 14 or 15 type of acquisition. And then we get into the sociological preferences of FAR Part 19. And a new person coming into this might look at FAR Part 6 and say, okay, I got it. I got it. Full and open competition. Always have full and open competition. And then they get to FAR Part 19 and it says, yeah, not so much on that competition. You know, we're really not going to do that this time. What we're going to do is we're going to set it aside to promote certain sociological preferences. And the new person is like, well, which is it? Do you set aside or do you have full and open? And the answer truly is both. And the reason it's both is because each of those is based on a different theory of jurisprudence. Why does the law exist? Competition says fairness to everybody. Sociological preference says we need to shape our society a little differently, and so we have to promote certain sociological objectives. And in a sense, they run headlong into each other. But once you understand the jurisprudential theory behind them, the whole FAR makes perfect sense. And by the way, almost every theory of jurisprudence can be found somewhere in the FAR. We did a study of that recently and determined that there were examples of most of the major theories of jurisprudence in the FAR. So from the prime to the subcontract, this chart is very important to understand that in federal contracts, you've got that entire body of law we just discussed that governs how federal contracts are managed. The subcontracts are commercial contracts between two commercial entities. And because of that, they are subject to the state commercial transaction statutes. And the disputes are not litigated in the federal courts, typically. They can be, but different examples. They're typically litigated in the state courts, which was the right-hand side of that chart I showed you earlier. And here we have the state Supreme Courts, from the intermediate courts to the trial courts. Speeding tickets are going to happen in the municipal courts, but most trials in the states are started at the trial courts. They go to the intermediary courts, which are typically courts of appeal, and then the state Supreme Courts. I caution any of you that happen to be in New York. New York did it differently. This is their Supreme Court, and the top one is their Court of Appeals, just the way New York does things. They're a state. They have their own sovereignty. They can do things any way they want to, and they do. But the key point is that the prime contract is going to be governed by things that happen on the left-hand side of this chart. The subcontracts are going to be governed by things that happen on the right-hand side of this chart. So consider this question. Could a prime contractor take an appeal from a contracting officer's final decision under the disputes clause of his federal prime contract through the process on the left-hand side of this chart and ultimately lose? And the answer is certainly. That can happen. Contractors don't win all their battles. They lose. And then, same prime contractor gets sued by one of their subs on the right-hand side of this chart. Same contract, same facts, same everything. Can the prime contractor say, oh, this is all settled. We went over here to the federal courts, and this is a settled case. And the state court will say, not in our eyes, because we have sovereignty over our commercial transactions. We will decide the outcome here. Could, in that case, the subcontractor win against the prime? And the answer is, yeah. And this happens all the time, too. So the prime contractor can literally be squeezed between these two bodies of law if they're not careful in how they set up the prime-sub relationship. And this is why understanding this concept is so important if you're going to effectively manage your programs with subcontractors. And studies have shown, and GAO has recently reported, that 60 to 80% of the prime dollars actually flow to the subs. So that's a big chunk of the work that's being done by parties who are not governed by the same rules that the prime contract is governed under. So hopefully you can appreciate the importance and why we think this particular webinar is so crucial for everybody to get their arms around and understand this. So what is this body of state law that's out there? It's called the Uniform Commercial Code, UCC for short. And these are different bodies of law with the different rules, procedures, and the outcomes, as I just explained. Now, a government subcontract is unique even amidst this because it is a hybrid in this sense. Legally, it is a commercial contract. However, under the UCC, the parties can agree to most any terms and conditions they want. And all of the federal flow-downs are those other terms and conditions the parties can agree to. And as you well know, if you work in this field, a tremendous number of the government prime contract clauses, the FAR clauses out of FAR Part 52, flow into the prime contract, sometimes by rule or regulation or otherwise, and then by the contract terms must be passed on to the sub. And that's okay under the UCC. But when it comes time to interpret those clauses, now you can have a problem, because the feds might interpret it one way, but the language showing up in a commercial contract would be interpreted by a state court judge who might not see things exactly the same way as a federal judge would. Now, this is where people like me come into play. I'm frequently called upon to serve as an expert witness in these trials. And most often, it's not to say one side wins or one side loses. Mainly, I'm brought in to say, hey, judge, you've never seen a federal contract. You have no idea what a federal procurement contract even looks like. I'm here to help you understand that, so that you can understand when you make your decision based on state court principles, how the federal principles come into play. And this is a very important part of the process, because without that, state court judges might make their decisions based solely on the UCC and not with the consideration of the impact of the federal norms that apply. Now, key differences in the purpose of the laws that follow that. If you're spending public money, certainly you want to have more rigid rules to make sure that the money's being spent properly and there's not any improprieties going on. But if your goal is to make it easy to do business, to expand commerce, then the preference is to have much greater flexibility in finding a contract. Does the contract even exist? Under the UCC, there's great flexibility and a desire to find a contract. Whereas with the federal government, as I'm sure you all know, unless you've crossed every T and dotted every I and have gotten every approval, there is no contract. And in fact, there is no contract until that instant in time that a warranted contracting officer affixes their signature to that document. For a federal contract, it's very easy to know when a contract comes into being. And it's that ministerial act of the CO that says, I approve this transaction in the name of the United States of America. That's great power. But that kind of clarity and rigidity is important when you're spending public money. On the commercial side of things, much more flexibility, and this is where some problems can arise. One policy of the UCC is to find a contract. They want to find contracts. Well, but we've left stuff out. Well, the UCC says that's okay. The UCC will fill in gaps for you. And they can be very important gaps, such as price, delivery, quantity, and quality. Furthermore, because of the flexibility of contracting, the code might say, generally, parties will do X. But the particular parties could say, you know what, in this case, we're not doing X, we're going to do Y. And the code says, it's okay, as long as you agree to it, we're good. There are certain obligations that cannot be disclaimed. Those involve primarily around the area of warranties and such things, and also makes a distinction between merchants and non-merchants. So, again, too much detail for present purposes. And I love this one. I'll give you the code section in a moment, but the UCC will be interpreted in such a way that you may say, well, okay, you're saying we got a contract, but I'm looking back over history, and I can't figure out when we did this. And the courts are going to say, we don't care. How you got here isn't important to us. The fact is you are under contract, and you have a contract even though we have no idea when it was formed. This sounds very strange, but in the flexibility of commerce, it's not as strange as it may sound. Now, good question to ask. How uniform is the Uniform Commercial Code? And the answer, depending on your viewpoint, is very uniform to, well, not so much. There have been successive drafts of the UCC, and various official versions have come out with revisions to them. And the UCC, in its entity, its whole entity, has been adopted by all 50 states. And some people say, oh, wait, what about Louisiana? Well, it's true. Louisiana did not adopt Article 2, which is the law of sales. But they have a common law principle. There's civil law jurisdictions down there where they follow their own rules. It's okay. It's got a lot of the similar stuff in there. But as you look across the states, the most commonly adopted edition of Article 2 is the 87 official text. Now they're moving more towards the 2001-2002 edition of that. And there was at one point a May 2003 edition, and it got withdrawn because nobody adopted it. And the uniform body of laws that drafts these things and, yeah, this is not serving anybody's purpose, so it's been withdrawn. So the 0102 is the one that is being most commonly adopted and viewed. But even within that, the states, as sovereign entities, can make changes, and they do. Code is to be liberally construed. It's designed to simplify, clarify, and modernize the law around commercial transactions. It is designed to be flexible to also allow for things that evolve, like technology, so that you can adopt more technologically efficient roles and purposes for entering into or getting out of contracts. It's designed to make the law uniform across the various jurisdictions and to establish a more uniform custom, usage, and basic agreement of the parties. Now, I want to talk about these three things real quick. I'm going to come back to it. Course of performance relates to a particular transaction. Say, for example, your contract says the subcontractor will provide weekly status reports. But as the contract's unfolded, you've only asked for them monthly. And the contract is well into performance, and the sub's been giving you monthly status reports. Can the prime then go back and say, whoa, whoa, wait a minute. Contract says you got to give these weekly, so you got to start giving them weekly. The sub can actually go to court and make the argument that they don't care what the contract says, because the party's performance is what defines the contract. And the performance has been monthly reports, not weekly. And they would most likely be successful in a claim to increase the cost to provide weekly reports instead of monthly, even though the contract already says got to provide weekly reports. Course of dealing takes a more expansive approach, a series of transactions. You ever seen that boilerplate clause that says, no contract exists until this contract has been accepted by the Home Office? And these parties have been entering into contracts and no Home Office has ever even seen them. Can one of the parties now say, oh, wait a minute, wait, we don't have a contract. It wasn't approved by the Home Office. The other party can say, it ain't how we do things. That's not how it's worked. Our course of dealing establishes that no Home Office approval is required. Courts are going to enforce that. And then the usage of trade, for example, if you want to build something and you want to use 2x4s, do not go out there with your little measuring stick and say, this board is not 2 inches by 4 inches. And that's because no 2x4 is 2x4. It's a smaller measure, but it's what stands in the trade as a 2x4. And as long as it meets that standard, it's acceptable under the UCC. So we're going to come back to these three things, but I want you to be aware that they are different, and they are significantly different in the way that prime contracts would be interpreted. Now here's the code language I mentioned, UCC Tu204. It can be made in any manner sufficient to show agreement. I mean, two cavemen could meet, and the one holds out a banana and goes, ugh, and the other one holds out a handful of berries and says, ugh. And the first guy says, ugh, ugh, and the second guy says, ugh, ugh, and they trade the banana for the berries and walk off. You just witnessed a contract, because it can be demonstrated in any manner sufficient to show agreement. Now, I know some of you believe that the people you contract with are cavemen. That's not where I was going with this. They may perceive you as the caveman in the transaction. The point is, under the UCC, it is very easy to enter into a contract if you have shown agreement. And here's the language that I mentioned earlier. Even if you can't figure out when the banana and the berries changed hands, you still have a contract. And that's an important thing to understand under the UCC. Battle of the Forms is another area that gets a lot of press and attention. Written confirmation allows for the existence of a contract even if the two parties have not come to agreement on the terms. One's put their terms forward, one's put the other terms forward, and the courts have come up with a way to reconcile those to make the common terms among the parties stick, and then the other ones apply as appropriate. And again, you can see where performance can actually dictate which terms and conditions truly do apply. You might question whether this negates the meeting of the minds. And the way the UCC approaches this is very simple. It says, look, it's clear you guys wanted to be in a contract. We'll fight later over what that contract says, but your actions say you wanted a contract. So the UCC says, you got yourselves a contract. Here's the part 2 of that article that talks more about that question of how do you know when it's over. And as I said earlier, frequently the parties aren't crystal clear in how they do put that together. Gap fillers. The UCC says you can leave the price out of your contract. Wow, you didn't leave the price out. In government prime contract, you'd never leave the price out of the contract. I agree, you couldn't. UCC, yeah, you can do that. And they will establish a reasonable price. Same with delivery. When, where, how? Reasonable time and place. The quantity, well, you got to have something in there about quantity, but it can be very soft, unlike a government contract that has to be very particular. For example, if I were to buy your crop of peas, how many peas is that? I don't know. Well, how many bushels of peas is it? I don't know. If it's a good year, it's going to be a lot of peas. If it's not a good year, it's not going to be a lot of peas. But it's a crop. It is the crop of peas. So you're okay under the UCC. And the same with quality. Generally, it's the standard commercial quality, which again goes back to the usage of trade. So these external things begin to define what the contract really is. And I ask here, so what happened to PDQ squared? Well, if you'll notice, that's price, delivery, quantity, quality. GAO a long time ago said, you know, if the government contract is not clearly stated, and these are the material terms, if it doesn't have a clear price, the delivery, the quantity, and the quality, the contract fails for lack of specificity. And so you may think you have a government contract, but if it's missing those key pieces, you don't have a government contract. On the other hand, if you have a subcontract and it's missing those key pieces, the code says, no problem, we'll fill them in. Do you again begin to see how, not paying attention to which body of law applies, the prime contractor can get themselves squeezed? I've known of cases where a prime contractor got the phone call from the CO that said, great news, we're awarding you the contract. And this prime contractor immediately goes out and formally awards all the subcontracts. And a week later, the CO calls and says, oh, there was a problem. The money got taken away, and we're actually not going to sign this contract. So you don't have a contract. And in fact, they don't have a contract. The phone call earlier didn't mean anything until the CO puts their name on the line. But what do the subs think? And what can the subs enforce? Because they're under a different body of law. This is why this area is so important. Now, I got a couple of quick charts here. The 2003 version of the UCC, one of the key things it did was it changed the delivery terms that we use. You should all be familiar with FOB origin, FOB destination. That means free on board. It pertains back to the old merchant law, and we've used that, and UCC has adopted that. But internationally now, those terms are going away, and we're going to a more international standard. So many of you have probably begun to see the Incoterms, as they're called, and there's the references up there for you. These are already being used in international contracting. And so you need to be careful of them. The next chart talks basically about how that came into being, and it applies to the sale of goods. And here is a whole bunch of the new terms, and the links would take you to where they can be defined. I give you the basic link. It's iccwbo.org, and you can go learn about those. But the point is, you are probably beginning to see these terms in some of your contracts because internationally, they are being more widely used. And that means on the UCC side of the house, they are going to be more widely used. Whereas on the government side of the house, until the regulations change and the FAR Part 52 clauses change, you're not going to see them. Again, conflict of laws. How do you deal with that? So be aware of that. I threw this one chart in here, and it's mainly just to give you a sample. We do an entire class on this subject of the differences between UCC and the FAR. And this is just 4 of the many, many things out of the 13 charts. Limitations on assignments. Government has an Anti-Assignment Act. Can't assign contracts except to a financial institution, etc. UCC, no problem. Make all the assignments you want. We're good with that. In fact, it facilitates assignments. A little different with delegations of responsibilities, but assignments, no problem. Duty of cooperation, well, that's common in both. You see that in both sides of the house. But then the excess costs of reprocurement, such as under a fixed price FAR Part 14 or any type of fixed price contract, UCC is different because it allows for cover, which is a particular type of way to prevent further damages, to mitigate your damages, and it allows consequential damages. And that's not typically done under a government contract. And the convenience by termination, termination for convenience, is one of those clauses that actually gets read into a federal contract, whether it's there or not. It's under the Christian doctrine. UCC, the termination for convenience clause, is treated as a breach of contract, entitling the non-breaching party to damages. So again, big conflicts between how the feds would look at something versus how the commercial entities would look at something. When you look at the UCC, there is an order of precedence. And earlier I gave you the definition of these terms because they become important. In FAR Part 15, you can find the order of precedence for federal contracts, and it starts with the cover page, Section A, and it moves through a series of things which then makes the statement of work the last in the order of priority of precedence when interpreting a contract. Here's how the UCC treats it. The first thing they look to is the express terms of the agreement. Well, that makes sense. The contract is what the contract says, if it says anything at all. If it doesn't, UCC is good with that, it'll fill it in. But look at the second thing. It will determine what the contract is by how the parties have performed the contract. And they will then look to the course of dealing across a series of transactions. And then they're going to look at usage of trade. So even the way a contract is interpreted as between the feds and the subs is completely different. And that becomes a critical distinction. So let me turn to the UN Convention, and I'm not going to spend a lot of time on here, although I've put a lot of data in the charts. I don't want to spend a lot of time on it, because if you're not familiar with it, this is a good chance to get a little familiar with it. If you are familiar with it, this is going to be pretty basic to you. But there are other legal systems out there, and there is this body of international law, particularly in the area of commerce, that is growing. These come from treaties, conventions, customs, etc. There are international courts, so there are judicial decisions and things that can be looked to. And the purpose of the CISG is to give a modern, uniform, and fair regime. And for developing countries, this can be critically important because they don't have a very mature body of law on which they can rely. But they can enter commerce and improve their economic standing in the world by appealing to the CISG, because now they have the commercial structure that's necessary to have enforceable contract agreements. The U.S. has signed this, as have many, many other countries, and so it becomes a treaty. And remember that Supremacy Clause I gave you way back in the beginning? A treaty counts as federal law and preempts any state law under it. And interestingly, the law will apply, the CISG will apply based on the status, the location of the parties. And so you may think you are under UCC, you may think you have accepted a particular state law, but based on where the parties exist, the CISG can actually be the governing law. So why is it important? Well, the CISG is a result of a very long effort, and it's gone through the UN. And interestingly, and it's interesting to me, a lot of things happen at the UN that, you know, half the world agrees with and the other half doesn't, and they fight over things, and you've got the Security Council, and you have all kind of things going on at the UN. This particular product of the UN has gotten more buy-in and more support than anything else the UN has ever done. And to me, that's significant. Internationally, people want to do business, and they want a framework within which they can do business. That's why the CISG is so important. Thus, its enforcement is important. And that's why you need to be careful that if you want to be under it, you say, I'm under it. If you don't want to be under it, you specifically say, I don't want to be under this law. It applies wherever the places of business are, and if the countries are party state. Now, party states means that you signed as a party to this convention. It doesn't mean the way you are on Friday afternoon in your office or how you were after your last final at a semester of college. That's not the party state we're talking about. We're talking about being in the country where you have the place of business. And as the second bullet notes, there are these odd circumstances where the place of business is not where somebody has an office necessarily. And so you've got to be very careful that you don't get fooled into having the CISG apply if you didn't intend it. It applies to the sale of goods. And you say, well, that's good, because that's what the UCC does. UCC applies to the sale of goods. But you know, if you read the UCC carefully, no, it doesn't. The UCC applies to transactions in goods, and that's different than sales. And once again, different body of law, different rules, different terms used, therefore possible different interpretations. It's very important. In this case, CISG says it's got to be predominantly for the sale of goods. Doesn't cover shares, stocks, investments, any of the commercial paper kind of things. And by its terms, it does not apply to the sale of services. So you enter into a contract and you say, well, I got this covered because we are going to apply the law of New York. And you say right in the contract, the law of the state of New York shall apply to this contract. And you say, okay, I'm good. I'm good. CISG is gone because we picked New York. Except, as I've tried to explain, what's the state of New York law say? It's under the U.S. Constitution, where the Supremacy Clause says federal law applies and federal law includes treaties, and therefore adopting New York law has made the CISG the governing law. And you say, well, that's not what we meant. And it doesn't matter what you meant. That's the effect. And so the CISG says, look, you don't want to follow this, fine, opt out. But you got to be specific. The parties hereby agree that the United Nations Convention on Contracts for the International Sale of Goods will not apply to this contract. A simple sentence. And I have occasion through my work to constantly review the standard boilerplate terms of a lot of different companies. And if you're with the big guys, with your Raytheon or Lockheed Martin and Grumman, you take your pick, their law staff has gotten together and they've put that language in your boilerplate terms and conditions. I never fail to see it. It's always there. When I'm dealing with smaller companies, however, and many of whom do deal internationally, I don't see this as boilerplate. And that can be a big, big problem. Now, the last bullet on this chart is important because it says it has additional opt-in and opt-out provision. You can actually opt in for part of it and out for other parts of it. But more importantly, it allows you to opt in for things the CISG does not cover. I mentioned on the prior chart, it doesn't cover services. But if you choose to, you can actually invoke the CISG as the governing body of law for services, if that makes sense. In other words, it's got to be a deliberative decision that helps you run through the risk profiles and say which body of law is best. And what we're seeing is too many parties are not giving this proper consideration, and they're going to be surprised if disputes arise. So run through a couple of quick things that are different amongst the three bodies of law we've now talked about. A contract under CISG can fail for lack of definiteness. For example, missing the price, or at least a formula to calculate the price. What's the UCC say? It says, no problem, we'll figure out a reasonable price. For the government, you've got that PDQ squared formula that says price, material, term, got to be in there. Revocability of offers. If there is a date by which it must be accepted, the offer is deemed irrevocable under the CISG. Under the UCC, until it's accepted, you can revoke an offer. There's some complicated provisions about creating a firm offer, but typically under the UCC, it's revocable. Under the government contract, you've got the firm bid rule under Part 14 types, but even in proposals, we'll have time limits. Now, they can be revoked prior to award under the government, but it becomes a little trickier in the process. Battle of the forms. CISG says mirror image. Offer, acceptance have to be mirror image. UCC says, yeah, not so much. You know, close enough. Show that you want to have an agreement. We'll give you an agreement. We'll figure out later what it says. Government, mirror image, once again. You have to make sure you cover all of the things the government requires. The statute of frauds is an interesting one because the CISG does not require the agreement be in writing. There has to be some evidence of it, and so what do they use? Well, they can prove a contract, the existence of a contract, by any means, including witness testimony. This is, you may have heard the parole evidence rule. If there's writing that controls and you can't bring in outside evidence, this is a rule of evidence honored by the American courts. Not so on the CISG. Anytime any way that you can show you have a contract, they'll take that. Therefore, just a practice note, if you're in a CISG type negotiation, take copious notes. Make records of the negotiations, because that will be determinative in many cases of what the contract truly is. The UCC used to have a $500 limit for the sale of goods. Most states have gone to a $5,000 limit. But again, this is an area where states can vary, so make sure you're following your state rules, whichever state you're using. And the government, always an interesting question, does a government contract have to be in writing? I ask this in class a lot, and most everybody would agree, yeah, a government contract has to be in writing, but the irony is, no, it doesn't. There is no law that requires the government contract be in writing. Now, don't get me wrong. It is really stupid not to put them in writing, okay? That's just bad management, bad practice. Don't do that. But legally, it doesn't have to be in writing. The writing requirement comes in when money is taken from the Treasury, and the expenditure of the funds must have documentary evidence. But the contract itself, not so much. So I ask you these questions. Given the types of risks that subcontracts can bring to you, you have to ask whether the professionals in your organization have been properly certified. Obviously, I ask this question in part because SCMI offers this certification, but more importantly, have they really been trained in all the different aspects that subcontracts bring to the table that prime contracts don't necessarily involve? And personally, I'd ask you, how many books have you read this year that pertain to your profession? If you're in this profession and you have not read Getting to Yes by Fisher, Urey, and Patton, you're missing out. You need to read that book. It's short, it's a quick read, it makes perfect sense. Use it in your negotiations. But there are books on the CISG out there. Some of them are a little legalistic and technical, and I acknowledge that. But have you even tried to read one? Have you gone and looked at it, see what it says? And does your organization even consider these risks of the differing bodies of law? In my experience, and I've covered a lot of companies, they don't. They don't think about this at all. And the last one, particularly for the smaller companies that might not have that disclaimer in their boilerplate, work with your counsel, whether inside or outside counsel, to improve the terms and conditions of your standard contract and keep them updated, whether it's a UCC governed contract or a CISG contract. And make sure the contract says what you mean for it to say. It's very, very important. So I want to spend a couple minutes talking about the certification program that I just addressed, and buried in here is a special announcement. You saw that on the table of contents. We have a special announcement for you today that personally I'm pretty excited about, but I hope you will be as well. When you seek certification, what do you expect? Well, the idea is to have a set of processes and procedures that facilitate good people doing good work, because in the final analysis, your policies and procedures are meaningless if you don't have good people using them or ignoring them. And it's very important that you have good people. And so you should constantly work to expand the skills of your team. A well-trained workforce working within a defined approved process will enhance your success of passing CPSRs. And this is important, you will be viewed as a preferred partner among the subcontracting community. Do you think there are times when you issue a solicitation and some of your possible vendors look at that and go, oh man, last time I dealt with those people, they were such a pain. I'm just not going to go through that brain damage. I'm not even going to offer to them. Yeah, it happens. Primes get a reputation, just as agencies get reputations for the way they do things. Certified people perform better, enhance your competition, get you a better deal, bring you better partners at the front end, and that's where the bulk of the difference occurs. The entire certification is 72 hours of structured self-study and 6 days of instructor-led training. There's 4 on a basic contracts course, 2 on the leadership and team building part of that. And what we're seeing is people seeing near-term positive results because they're not making dumb mistakes and they're more disciplined in their practice of contract management, particularly at the sub-level. Now, with that in mind, there's a new book coming out, and yes, I'm the author, self-disclosure. You can see it. That's the cover of the book. It's in print right now. I'm hoping to have some copies available by World Congress, if you're going to be at World Congress. But if not, we'll still have the pre-sales and those kind of things available there. But SCMI has already agreed to include this in their certification program. So if your certification class starts October 2017 or later, you will get a copy of this book, and you'll begin to see how sustained leadership takes a very structured and disciplined approach using the work breakdown structure, the WBS tool from project management, and essentially walks you through the process on how to build yourself into a better leader. And if there's one thing we need in the world today, it's better leaders across every spectrum, whether it's politics, government, business, industry, even charities, and service organizations. Good leadership is desperately needed, and we don't see enough of it. This book is in part designed to help fix that. So, as I said, I'm pretty excited about it, but you'll get a copy of that if you take the certification class after October 2017. And it'll be in all the bookstores, Barnes & Noble, Amazon, etc., when it comes out. So interested in your feedback when you see it, and it'll be part of this class. SCMI gets great reviews for its training, and this is a couple of things that people have said. In one class, we had one person drop out, so there were only 29 people in it, and 29 of 29 said they would recommend this to the other employees. And in fact, the company where that was done has already scheduled their next round of 30 people to come through the certification program. We're not always allowed to talk about who they are because they see this as a competitive advantage, and I'm inclined to agree. You do this well, you've got a competitive advantage, and so we encourage people to seek that. If your company is interested, here's how you go through the process. And by the way, when we say 30 candidates, you don't have to have 30 buyers or subcontract administrators. The certification program SCMI offers covers the technical team, the cores, if you will. The technical representatives are part of this team, and they are included in this. And in several companies that we've worked with, they have brought their subs into this class as part of the team to learn this all together. And it's been tremendously useful to them, particularly when you have long-standing key subs that you use frequently. It's not that difficult to put 30 people together to do this and get yourself certified. These are the reps. I cover the Midwest because I'm in Denver, although I'm not there today. I happen to be in Baltimore. But typically I'm in Denver, and I've got the Midwest region. Vic's got the West Coast. Bonnie's got the East Coast. And so you can reach out to any of us. Any of us can help you, but generally speaking, we try to split things up so that we don't get too overburdened in one area. And we've got future webinars coming up. Next month, we're going to talk about the flow down dilemma, what to include, what to exclude. This is a very important one as well, and it's an area of constant consternation. And so I want to make sure that you see these as well. Now, I want to take a quick look over here and see if I've gotten any other questions. And apparently I misspelled mistake somewhere. I'm going to have to go back and look for that. I had the word turn instead of term in one of these charts, and I caught it like 10 minutes before we went on the air here. And I was thinking, yeah, the little white bird's probably not going to help people there. And looking into the chat to see if anybody came up with questions there. I have no particular questions. We have increased our attendees since we started, and I welcome you all to be here, and hope you got a lot out of it, and hope you didn't miss too much at the front end. But with that in mind, we have no other questions. We have about 1 minute before the end of class, and with that in mind, I will end with this chart right here. SCMI is based in Washington, D.C. We have our own phone numbers there. You are certainly welcome to reach out to me. That's my Denver number, and I'll be more than happy to help you as well. But I do hope you've gotten a lot of good information from this today. I hope you have come to appreciate these 3 bodies of law. Frequently people only think of the 2, but there's a 3rd one, and they are all different. They all have different outcomes, different rules. Knowing when you have a contract, and if you don't have a contract, what it is you do have, and how do you know when your contract is over? And all of that is critical to good contract management and subcontract management. So I thank you all for being here. I thank you for participating today. And again, I hope it answered a lot of your questions. And feel free to reach out to us at any time. Thank you for the hour of your life you spent with me today. I hope that you can put it to good use. Hope to see you in a future webinar. Goodbye now.